Hello, welcome to my channel. Today, we are going to study criminal procedure for the uniform bar exam. First, we are going to learn the basic key law regarding search for the UBE. The Fourth Amendment prohibits unreasonable searches and seizures by the police and citizens acting at the police's direction. A search is a government intrusion where a person has a reasonable and justified expectation of privacy. A warrant is required to conduct a search, unless an exception to the warrant requirement applies, such as the exception for a search incident to arrest. Probable cause to make an arrest exists when an officer has trustworthy facts sufficient for a reasonably prudent person to believe the suspect committed a crime. Now we are going to read through a regarding question. The police suspected that John, a 16-year-old high school student, had committed a series of burglaries. Two officers went to John's high school and asked the principal to call John out of class and to search his backpack. While the officers waited, the principal took John into the hall, where she asked to look in his backpack. When John refused, the principal grabbed it from him, injuring John's shoulder in the process. In the backpack, she found jewelry that she turned over to the officers. The officers believed that the jewelry had been taken in one of the burglaries. They arrested John, took him to the station, and gave him Miranda warnings. John asked to see a lawyer. The police called John's parents to the station. When John's parents arrived, the police asked them to speak with John. They put them in a room and secretly recorded their conversation with a concealed electronic device. John broke down and confessed to his parents that he had committed the burglaries. John was charged with the burglaries. John moves to suppress the use of the jewelry. The court should A. Grant the motion on the ground that the search was conducted without probable cause or a warrant. B. Grant the motion on the ground that the search was conducted with excessive force. C. Deny the motion on the ground that school searches are reasonable if conducted by school personnel on school grounds on the basis of reasonable suspicion. D. Deny the motion on the ground that the search was incident to a lawful arrest. Before I release the answer with the reason, I am going to wait for you a little bit. Or you can pause the video if you need. Can you guess what the answer is? Alright, as you guess, the answer is A. Grant the motion on the ground that the search was conducted without probable cause or a warrant. This is because the Fourth Amendment applies to the principal's conduct. Because the police asked her to search John's backpack, the police did not have a warrant to search the backpack. Further, while the facts indicate that the police suspected John had committed a series of burglaries, mere suspicion does not rise to probable cause to make an arrest. Thus, the court should grant the motion. Well, do you want another question? Then, please hit the thumbs up right now. Prior to the next question, let's learn about one of warrantless searches under the Fourth Amendment. Under the Fourth Amendment, a search is government intrusion, where a person has a reasonable and justifiable expectation of privacy. An area viewable from a flyover is deemed held out to the public, so there is no reasonable expectation of privacy in such an area. Thus, a flyover is not a search. Now we are going to read through a regarding question. Police received an anonymous tip that Kate was growing marijuana in her backyard, which was surrounded by a 20-foot-high, solid wooden fence. Officer Taylor was unable to view the yard from the street, so he used a police helicopter to fly over Kate's house. Taylor identified a large patch of marijuana plants growing right next to the house, and used this observation to obtain a search warrant. Kate is prosecuted for possession of marijuana and moves to suppress use of the marijuana in evidence. The court should a. deny the motion, because Kate had no reasonable expectation of privacy from aerial observation. b. deny the motion, because a warrant is not required for a search of a residential yard. c. grant the motion, because Kate had a reasonable expectation of privacy in the curtilage around her house and the police did not have a warrant. d. grant the motion, because the only purpose of Taylor's flight was to observe the yard. Before I release the answer with the reason, I am going to wait for you a little bit. Or you can pause the video if you need. Can you guess what the answer is? Alright, as you guess, the answer is A. Deny the motion, because Kate had no reasonable expectation of privacy from aerial observation. This is because the Fourth Amendment applies to the principal's conduct. Because the police asked her to search John's backpack, the police did not have a warrant to search the backpack. Further, while the facts indicate that the police suspected John had committed a series of burglaries, Mere suspicion does not rise to probable cause to make an arrest. Thus, the court should grant the motion. One more question? Then, please hit the thumbs up and subscribe right now. Here we go. The police had, several times, accumulated reliable information that Xavier operated a large cocaine distribution network, that he and his accomplices often resorted to violence, and that they kept a small arsenal of weapons in his home. One day, the police received reliable information that a large brown suitcase with leather straps containing a supply of cocaine had been delivered to Xavier's home and that it would be moved to a distribution point the next morning. The police obtained a valid search warrant to search for and seize the brown suitcase and the cocaine and went to Xavier's house. The police knocked on Xavier's door and called out, "Police, open up. We have a search warrant." After a few seconds with no response, the police forced the door open and entered. Hearing noises in the basement, the police ran down there and found Xavier with a large brown suitcase with leather straps. They seized the suitcase and put handcuffs on Xavier. A search of his person revealed a switchblade knife and a .45 caliber pistol. Xavier cursed the police and said, "You never would have caught me with the stuff if it hadn't been for that lousy snitch Harvey." The police then fanned out through the house, looking in every room and closet. They found no one else. But one officer found an Uzi automatic weapon in a box on a closet shelf in Xavier's bedroom. In addition to charges relating to the cocaine in the suitcase, Xavier is charged with unlawful possession of weapons. Xavier moves pretrial to suppress the use as evidence of the weapons seized by the police and of the statement he made. As to the switchblade knife and the .45 caliber pistol, Xavier's motion to suppress should be A. denied, because the police had reasonable grounds to believe that there were weapons in the house. B. denied, because the search and seizure were incident to a lawful arrest. C. granted, because the police did not inform Xavier that he was under arrest and did not read him his Miranda rights. D. granted, because the search and seizure were the result of illegal police conduct in executing the search warrant. This time, if you know the answer for this question, type your answer with the reason in the comment box. I will leave the answer on my Instagram study 4 bars. Follow me on Instagram and check the correct answer of this question. I hope today's video was helpful to your bar study. If you want to study more for the UBE, don't forget to subscribe. Happy study!